And welcome back to the special audience edition of Hannity. And we also now are going to be bringing in our studio audience. But first, let's go to amendment number 3, an amendment to establish term limits for the Supreme Court justices and a supermajority legislative override. Audience, agree? Hands up. How many disagree? All right. Well, this I support. Go ahead, Andy.
I just have one tweak. Why a supermajority, Mark? You know, why a supermajority to override the Supreme Court? In a regular Supreme Court case, one unelected lawyer can shift the balance. Why do
because today it's 0, and so and I do respect the notion of the independence of the Supreme Court, and I'm not advancing the notion of majoritarianism. So I do think there ought to be a higher threshold. But I really don't believe there's any historical justification whatsoever, and I would challenge anybody to present it, to have one person on the Supreme Court shifting the nation radically in one direction or another on a whole host of issues that don't even belong in front of the Supreme Court, that belong in the states, if even there. These are 9 imperfect human beings. Historically, some have been extremely imperfect. The Supreme Court's had some great decisions and some real doozies. I'll give you an example. Dred Scott is the prime example, but there are many. What if we had recourse to Dred Scott short of civil war? I mean, why? Look at Roe v. Wade. Whatever your opinion is, the nation is permanently divided on this without resolution because a handful of lawyers impose their will on the American people. I don't know how you can call this a constitutional republic when something of that nature occurs. Judicial review is an implied power in the Constitution. It's not even there. Somebody has to make a final decision. But a final decision that affects society so thoroughly, and the society is still anxious and frustrated by it, there has to be some kind of recourse to it. And why shouldn't it be a broader segment of the population, a broader segment of society, 3/5 of the state, not popular vote, 3/5 of the states? You know, we conservatives, we talk about federalism all the time. So do we support federalism or don't we support federalism? Are the states so rotten and the federal government so wonderful? Is the Supreme Court so beautiful and nobody else can make decisions? I don't believe that for a minute.
Anybody want to respond to that? Somebody?
I have silenced them.
Yeah.
Oh, no.
Jeffrey Lord.
Not.
Go ahead, Jeff.
Talk about, you mentioned in your book, settled law. I mean, I remember Arlen Specter grilling either John Roberts or Sam Alito about, well, can't we consider Roe v. Wade settled law? The fact of the matter is we don't think it's settled law. So how do we decide what is, quote unquote, settled law in terms of opposing these things?
Well, it is more settled if society more broadly makes the decision. It is unsettled if a Supreme Court uses invisible ink and adds language to the Constitution that simply does not exist. And this is a broader point I'd like to make. The left is into nullification. The left nullifies the Constitution. It nullifies parts of the Constitution. And then when somebody like me dares to say, well, let's embrace that part of the Constitution that allows us to reestablish it, they, what, oh, you don't support the Constitution? So these people are doing their fan dance. And what I'm saying is, trying to be as consistent as I can, these are suggestions I'm making to reestablish a constitutional republic. I don't have unassailable knowledge here. If we ever get to the stage of a state convention, I sure as hell hope we do, then we'll have an opportunity to avoid what I think is you know, as a republic, doom. Because I don't think we have a lot of time, and I think this is something I hope that people will begin to talk about, whether they agree with a particular amendment or not.
You talk about Lincoln and Dred Scott. You talk about Jefferson. He was upset over Marbury Madison. In the book, you also talked about Woodrow Wilson, and you said endorsing judicial tyranny. So you look at basically 3 phases where they have accumulated a lot more power than you think was originally intended.
What's particularly interesting, as a side note about Marbury versus Madison, there seems to be belief, conservative, liberal, everything in between and around, that was a great decision. Well, at the time, it was considered a power grab by the Supreme Court, by Jefferson and Madison and others. And Jefferson's archenemy was in fact, Marshall. Marshall was the Secretary of State who signed those certificates for the judges who later sued when Jefferson became president, claiming that they had a right to those appointments. And Madison was his Secretary of State and said, no, you don't. And then there's Marshall, who's Chief Justice of the United States Supreme Court, ruling on decisions that he made. And apart from that, saying, hey, look, we have the right to make some of these decisions on the Constitution. Somebody has to, when it wasn't even a constitutional question. All I'm saying is, great, Marbury versus Madison. Today, the court's judicial review is judicial activism. I'm not even talking about judicial independence. I'm talking about judicial supremacy. I read these cases as part of my living that I make. Some of them are so outrageous and outlandish. And to sit here in June every year, to sit on the edge of our seats, to wait for some breathtaking decision coming down from on high, when you read it and you say, good God, what a knucklehead decision here, and it affects the entire nation, I think a great republic can do better than that.
We'll take a break. We'll come back more with our studio audience and the great one, Mark Levin.